Advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon. Carl Rominger here, 540-0580. What's going on out there? I got my Starbucks, so I'm ready to go. I know I'm on time, Shane, when I have the Starbucks, see? Because I get off the highway down here, I have to make an evaluation of my situation, and I go, all right, 6 minutes to airtime, Starbucks, usually 8 guys in line. Nope, can't do it. But, once every 3 months or so, I have enough free time to grab it.
I know you're on time when you're sitting right across from me and I can see you.
Well, yeah, you know. But that sometimes you guys get a little nervous around here for some reason, particularly when I'm filling in for Durgan. They get really nervous. All right, 540-0580 if you got a legal question. And, of course, I got to fill in for Durgan twice this week, so I was answering some legal questions on the air through the week, and I enjoy doing that. What I like about doing the Durgan show, too, is we get to talk about, a little of everything. Of course, here we mainly focus on the law. Every once in a while we get a little off topic and go into politics or, tea parties or things like that. But for the most part, get your legal questions answered. If you have a personal injury case, somebody was hurt in a car accident, you have a custody case, you got a land dispute, wrongful death, pretty much anything, we'll talk about it. Paul, you're on WHP 580 with Carl Rominger. What's going on?
Hello.
Yeah.
I had a fender bender where a driver rear-ended me. There's minimal damage to the car. My question is, in Pennsylvania, we have no-fault insurance, correct?
I mean, basically.
Well, it's my understanding that my insurance company will pay for the damage on my car, and then they will do what's called, if I believe, subrogation.
Correct, with the other insurance company to see which, between the two insurance companies, who do they believe is at fault?
Well, the other driver was cited by the police for following too closely.
Okay.
All right. So my question is this. There is a deductible on everybody's policy. Am I still responsible for the deductible, or does the insurance company go after that? Or would I have to hire an attorney to get that out of them?
Right. The short answer is when your insurance pays for something, you're still responsible for the deductible. The other side is responsible to pay you that deductible if they're at fault. So your insurance company could do it two ways. You could put it through the other person's insurance, okay, the initial claim, which is probably the smartest thing to do, and then they'll just pay everything.
Okay.
Or you put it through your own insurance, and if they want to handle it, then you're right. You're going to be out to deductible, and then they're going to subrogate with the other side, and then the other side should pay you the $500. But you're right. You may not always collect it. There may be an issue. And just because the police have cited somebody doesn't mean necessarily that's how it's going to end.
Right. Okay.
So I would usually recommend going through the other party's insurance. Where this really becomes an issue is when the other party doesn't have insurance, obviously, and they're the responsible party. Then subrogation is possible, but not always helpful.
Yeah. Well, let me ask you this. Now, also, according to Pennsylvania law, if I'm correct, you are responsible for reporting it to your insurance company. So I did that online. It happened Friday, and it was, midday, so I've not heard back from them just yet. Now, the other party's insurance company did call me, so I'm wondering, can I still put it through to them and say, look, I expect this deductible to be paid given the fact that your client hit me?
Yeah, you can do that.
All right, cool.
All right, boss. And also, if it doesn't work out, what you end up doing, you can just go to small claims court and sue the other side. And theoretically, the insurance company has to indemnify them. So that you can sue for your deductible.
Okay, good.
All right.
Thanks a lot.
All right, boss.
Bye.
540-0580. Greg, you're on WHP 580. What's going on?
Yes, Carl. My wife and I are separated, and she visits with my children on the weekends.
Mm-hmm.
And last weekend, my wife, who has bipolar disorder, struck my daughter.
Okay.
Now, I called Dauphin County Vocational Witness and they told me that I had no case for a PFA.
Okay.
Now, I'm just wondering, is that true or not?
No, I mean, you do have a case for a PFA. If she struck someone, that's enough. Now, when you say struck, I mean, was this a spanking or what was the issue?
No, my daughter blocked. She doesn't know if it was a punch or was going to be a slap, but it was toward the face or head region.
Mm-hmm.
And my daughter said she didn't get to see it because she blocked it with her arms.
Well, what was the issue? I mean, how did this come up? I mean, were they fighting about something or? Well,
my wife demanded that my daughter shower at her father's house.
Mm-hmm.
And my daughter did not feel comfortable with that.
Okay.
And so my wife was demanding that she do it. And then
Did you actually witness this?
No, this is what my children told me.
Okay, and how old's the child that's telling you this?
14.
14. Yeah, I mean, it's potential PFA material. It's also custody material. Couldn't go back to custody court with it.
Yeah.
But here's the problem. The proof issue is going to be, what was really happening. And now the equivocation here is your daughter saying she wasn't sure if it was going to be a slap or a punch. What if the mom comes in and says it wasn't going to be either? It was just going to be me grabbing her by the shoulder and dragging her to the bathroom to throw her in the shower because she smelled bad.
Well, the thing about it was she was going after my daughter a second time.
Okay.
And my younger daughter, who's 12, jumped up and said, "Knock it off, Mom, or you're going to fight with all of us."
Mm-hmm.
So.
Okay, so there's a little more to the story after that. It looks like there was some aggression.
Yeah.
I think you could potentially get a PFA, yes.
Okay. Because I don't know why the wacky woman there at Dauphin County victim witness told me, the judge will just throw this right out of the court.
I don't think that's necessarily true. The PFA judge in Dauphin County is known to be pretty solid, and obviously they've got to determine, you've got to prove that there was abuse or threat of abuse by preponderance of the evidence, and that puts your daughter in reasonable fear of harm. Now, we got to ask, what's the custody situation? Could you address it in custody court as well?
Well, we have shared custody.
Right, so you could go to custody court and say, Judge, bipolar, we've got some issues here. We need some safety plans in place. And if there's any additional hitting or abuse, then the girls need to be able to, remove themselves from the situation.
Yeah. Well, that was the thing. I have a daughter, 12, and a son, 10.
Yeah.
And she has abused the son as well.
Okay, well, it sounds like you really should get into custody court, number one. PFA is a temporary fix, but it's not going to handle the custody issues.
Okay.
All right?
All right, thank you.
Good luck, my friend. 540-0580, Carl Rominger here. I want to take a chance to tell you guys about Carlisle Beer and Cigar. And they're at 770 Southwest Street, Carlisle, Pennsylvania. Phone number over there is 249-2434. They've got a great selection of cigars, a little of everything. And if they don't have what you like, they can pretty much get you anything. And I know a couple guys that smoke cigars regularly in Carlisle have gone over and told them what they like, and they now stock them. They also were kind enough to provide me with some Sierra Nevada Ruthless Rye and Newcastle Brown Ale. So I appreciate that. I'll get back to the Sierra Nevada Ruthless Rye. I haven't drank it yet. Newcastle Brown Ale I've drank many times before, which I enjoy very much. But Carlisle Beer and Cigar, 770 Southwest Street in Carlisle, which, by the way, is right by the Walmart. So it's basically the beer distributor by the Walmart in Carlisle. When you stop in to get a cigar, tell them Carl sent you. Or if you stop in to get a beer, tell them Carl sent you, just so they know that people actually do listen to this show. By the way, CDL Labor Logistics is still seeking experienced, qualified commercial drivers with clean records for long-term, high-paying driving positions, both local and regional. And, of course, they have an ad here on the show. They're also looking for team drivers with a guaranteed $75,000 a year. So call 866-293-1880. Again, if you're a CDL driver and you're looking for some job opportunities, and be sure and tell them Carl sent you again, because they're trying to keep track of who sends their business. And like all small business owners, you probably know, tracking where your business comes from and what works or doesn't work is difficult. So just let them know Carl sent you over there to CDL Labor Logistics. If you're a truck driver looking for a local job, a regional job, or some team driving, 866-293-1880. See you after the break. All right, I'm back. 540-0580. Get your legal questions answered here. Of course, we'll be on until 3 o'clock. Of course, you can always join us on Facebook. The Rominger & Associates page has exclusive content, as does my own personal page. And, of course, if you friend my personal page, you can get access to me on a 24/7 basis to just shoot me questions. And I don't guarantee I get back promptly, but I am available, and I do screen those and pay attention to what's going on. Oh, yeah, by the way, I want to give a shout-out to my buddy Adam for running his first half marathon. It looks like a marathon time based on what he posted, as opposed to a half marathon time, but it's still very impressive. Particularly if you saw the man, you'd understand what I'm talking about. Martha, you're on the air. Hey, Martha.
Hi, Carl.
Yes.
I called you earlier in the year. I put in for went to JP and put in for a bad check.
Yeah, what happened?
How long does it take to do that? Because that was back in January that I did that.
Well, you filed with the JP?
Yes.
They give you a court date?
They did not.
That's strange. Did they get service on the other side? What's going on?
Well, see, I wanted to talk to you before I called them and talked to them again about it.
Uh-huh.
Because I haven't heard anything.
Well, if you filed something with them, then there should be a docket number, and you should be able to figure out what's next on the schedule for it.
Uh-huh.
I would talk to them, because that's way too long. You should have heard something by now.
Yes. Well, I was thinking.
Yeah.
So maybe they can't find the guy? Or...
That's possible. Maybe they're not getting service.
Yeah. So if they can't locate him, then that means it's going to take longer.
Well, if you can't locate him, you can't get a defendant, then there's nobody to sue, right?
Well, that's true. I don't think he's dead. He's probably just hiding somewhere because he owes people a lot of money.
Yeah.
Yeah. Okay, well, I'll do that.
If the JP can't find him, the other option might be to take it to the police and report it as a criminal matter as well.
Okay.
All right.
Okay, thank you.
Good luck. 540-0580. Carl Rominger here answering your legal questions. Emily, you're on the air. Emily?
Hi. I have a question about a landlord-tenant situation.
Yep.
And there's a dispute or possible dispute. The landlord thinks that he can keep the security deposit because the tenant didn't give 30 days written or notice, and the tenant thinks that they can get the security deposit back because the apartment was not damaged, it was clean, and so I would like to know what the law is.
Well, the security deposit has to be returned if there is no damage to the place and there's no money owed, okay?
Okay.
To the extent that the landlord's going to restrain, or I should say distrain any of the security deposit, they've got to give written notice of the damages and reasons.
Okay. There were no damages, but the tenant did not give 30 days notice. They only gave 12 days notice, and the landlord said that it was a verbal agreement that they would give 30 days notice from the first of the month.
Well, if there's no other agreement, okay, written agreement, generally everybody's on what's called month to month.
Yeah, it was just a verbal agreement.
And so if you're on month to month, you've got to give notice that you're moving out. So each month that you're in, that's your month. So it would seem to me that the landlord might be right here that the tenant walked early without sufficient notice. Now, the tenant's going to say, well, we had a verbal agreement, right?
Right.
And how do you prove that?
I have no idea.
That's what I mean. How do you prove it? And so I think there's a strong presumption that the landlord would prevail, because the landlord's going to say, no, we didn't have that agreement. And the tenant's going to say, sure we did. That's why I did what we did. And the judge is going to say, I can't figure out who to believe, but you, tenant, are the one who's asserting it's a little bit different than normal, so you have the burden of proving it.
Yeah, I'm not the landlord nor the tenant.
No, but you understand what I'm saying? What the judge is going to say to the tenant is,
right.
The burden's on you to show that this is being done a little bit differently than normal. So if I can't figure out what the verbal agreement is, then I'm just going to let it go like it's normal.
Okay.
You understand how that works in court? Sometimes there's a certain presumption that things are going to work a certain way, or a standard way that things work. And one would assume that absent a writing or specific proof otherwise, that's how it is. And so the tenant comes in and says, oh, well, we had an agreement. And the landlord says, no, we didn't. And the judge says, well, I'm having trouble figuring out what the agreement was, if anything. Therefore, I'm not going to find that the agreement's been proven. Therefore, we're going to go to the default position, which is it's month to month.
And does that mean that the landlord has to give the security deposit back, or what?
No, I think if they didn't give notice that they were intending to vacate sufficiently, then the landlord's going to say, hey, I was entitled to 30 days notice.
Right. Okay, so is it worth pursuing?
From whose standpoint? The tenants?
Either one.
Well, I don't think the tenant's likely to win.
You don't think they're likely to win?
Right. They have no proof of this agreement.
Okay.
In other words, what's the lesson here?
Put everything in writing.
Yes. Thank you.
Yes. Well, thank you so much for your help.
All right. Bye. I just like when somebody gets the lesson right, you know? So at the end of the school, at the end of the fable. And what's the moral of the story? Quit while you're ahead. Jane, you're on WHP 580. What's going on, Jane?
I have a question for you. Is it possible to write a lease that cannot be broken?
Well,
I mean in the sense that, you know, you set a lease for a certain period of time for 1 year, and you've agreed on a certain monthly amount. So at the end of the lease, they're going to pay X amount of dollars.
Right.
And to have it worded in the lease that, you know, this is the agreement and there's no getting out of it early. Do you have to let someone out of the lease early?
No, you don't have to let anybody out of a lease early. That's the whole purpose of a lease. It protects the landlord and the tenant and defines the obligations. Now, there are exceptions, okay?
Okay.
There are ways out of leases. So, for instance, if the landlord turns the water off to the apartment, you can claim to have been constructively evicted, and therefore they broke the lease.
Military, you have to let out under the military addendum.
Yep.
Right.
But
assuming that the landlord meets all of their requirements in the agreement.
The tenant is stuck.
Okay. So if the landlord says, look, you've agreed to a year, you've agreed to this price, this is what you have to pay. If you want to leave early, you can go ahead, but you're going to pay out the lease.
Correct.
Now, what happens? Tenant says, okay, they drop the keys. They say, all right, I'll start paying you the money. And you re-rent the property to a different tenant.
Interesting question. Depends when that happens. And what I mean by that is, theoretically, if you break the lease, okay, the landlord then has a duty to cover. So if I just walk away from the lease, if I just walk away and say, I'm not paying the lease, the landlord can sue me for their damages. And they have a duty to try to cover, which means to try to rent the thing. So if they rent it right away, their damages may be very small, okay?
Okay.
But the lease might also have a liquidated damage clause in it that says it doesn't matter. This is the amount you owe, which is the remainder due under the lease as a liquidated amount of damages. So generally, courts are going to enforce the liquidated damage clause. If the liquidated damage clause is disproportional or obscene or unconscionable, right? You'll pay me $1 million if you break the lease, 1 year lease on the $1,000 a month apartment. A court would probably not enforce that. But
now, what if you just ask for the balance of the lease?
Well, that's what I'm saying. I'm saying that you put the balance right as liquidated damages. That's probably reasonable and will probably be honored. So a liquidated damage clause would probably protect the landlord in that case.
Okay. One other quick question, kind of in the same field. Say the lease ends. You've signed a year lease. It ends. Tenant comes to you, says, I need an extra 5 days to get my stuff out.
Right.
Do you have an obligation to prorate those 5 days, or can you just say, okay, I'll give you 1 more month then?
Well, they become a holdover at that point, and if it's a well-written lease, it's going to describe what happens with a holdover.
Okay.
So a well-written lease is going to say that to the extent you remain past your date, you're now a month-to-month holdover who's subject to immediate eviction, basically. So that's usually what it would say. You could have a proration clause in there that says, that if they want to hold over, that they be prorated rent per day. But I don't see how that would be to the landlord's advantage.
Right. Right. We're thinking just stick to 1 month.
Right. On the other hand, the problem is, right, if you give them 1 month, and then they might go, well, I got 5 days, but now I got 25 more days to just kind of take everything one garbage bag at a time over to my new joint. Right. So in that regard, there might be a little bloop in there because you may have been thinking, I need to, I need to figure this out. So you might want to have a holdover clause that allows them to become month to month or prorated daily at landlord's sole discretion. Okay.
Okay.
All right. Good luck.
Thank you very much.
All right. Yeah, at least it can't be broken. The answer is all contracts can be broken. The question is, what are the remedies when they are? And I know that's what she meant, but I just kind of chuckled a little bit because can I write a lease that can't be broken? And I think of that old Cadbury ad where the devil selling the recipe for the Cadbury to the guy who's willing to give up his soul. That might be a contract that can't be broken. But a lot of fiction and fantasy have that contract getting broken pretty regularly. 540-0580. Carl Rominger here answering your legal questions. We'll be back after the break. Okay, welcome back. What you need when you're out there speeding or driving recklessly is Justin Bieber's security team with you. Apparently they can come up with video, allegedly, they haven't handed over the cops yet, showing that he wasn't behind the wheel, it was somebody else, and that he was only parking the car in the garage because parking the Ferrari apparently is a tricky maneuver with the low-riding car. Now, I call horse hockey on that one because think of all the cars that are tricky to drive, or tricky to drive, say tricky to park. What's tricky to park in a garage is grandma's, Lincoln. Not a Ferrari, which is for all intents and purposes a teeny little thing. They're not giant cars. So I'm not sure that parking it's tricky. It might be tricky if you've got a lead foot and you hit it a little too hard. I mean, you don't want to bump the car. I understand that, but I'm just saying. And of course, when this video will be handed over is probably after they're done making it. Jay, you're on WHP 580. What's going on?
Hi, Carl. I haven't talked to you for a while, so
yeah.
Before I left, I thought I'd just call to say hello. And you said something earlier about you could post questions. I wasn't sure I caught that, and you'd answer them. Now, you're talking about legal questions, the kind of questions I ask you in Facebook.
On Facebook, I get a mixture of people's legal questions, political questions. Here's a picture. What do you think of that? But I also get a lot of private messages that are sort of like, hey, my daughter just got a DUI. What can I do?
Well,
can I call your office? Those sorts of things.
Yeah, well, I don't have any legal. I'm always curious about your opinions. Like, you were talking about cigars, and I smoke an occasional cigar, but I'm having some problems from my years of smoking, I guess. And it just occurs to me, here we have a society that's, smoking's okay, it's legal if you smoke certain things.
Right.
I'm sitting there thinking, and I'm certainly no pothead. I mean, it's been 30 years, but I said, well, what makes marijuana so dangerous and tobacco so undangerous? And
I'll tell you what it is. The DuPont Corporation, in conjunction with Argyle Hearst, convinced the masses that pot was bad, evil, and likely to lead to the,
Yeah, I've seen the movies, too. And I know, I just think it's... And what always other thing that kind of gets me, and I listen to your show, and you just pointed it out, I would never consider any kind... I've been on both sides as a owner, as a tenant. I would never consider a lease without some sort of written document. And I did let a guy stay in the house for 3 months, but, he wasn't paying, and that was fine, but I would never consider it. And it's amazing to me how many people just do this handshake thing.
Right.
I know that was the way it was done maybe 50 years ago, but not with strangers.
Yeah, to me, it's probably not the greatest idea.
Yeah, so, okay, gotta run.
All right, my friend, take care. 540-0580, Carl Rominger here answering your legal questions. Dan, you're on the air. What's going on, Dan?
Hi, this is Dan.
Yep.
I paid for a guy's funeral expenses, and the will is about ready to be wrapped up. Is it possible for me to recover what I spent on that?
Okay, so you paid money for the funeral.
Yes.
And there's an estate open?
as far as I know, yes. Most of his wealth was in his house, and they closed on that about 2 weeks ago.
Yeah, the estate should reimburse you for the funeral expenses. What you should do, if you're not in good communication with everybody, which is what it sounds like,
yes.
You should file a notice of claim against the estate in the courthouse.
Okay. And I can get somebody like you to take care of that for me.
Yeah, or you can go. I mean, it's a pretty simple document. It basically just says, "Hi, my name is, and I'm owed this much money by the estate."
Yes. Okay. All right, then. I guess that's all I need to know. Thank you very much.
Goodbye.
Bye-bye.
540-0580 is the talk line number. Of course, we'll be here till 3 o'clock. So if you're frantic going, "How can I can't have time now?" You've got another hour and 20 minutes to call in here. John, you're on WHP 580. What's going on? Hey, John.
John. Oh, okay. I have a brother that's in a home, and if I get a power of attorney, am I liable for any financial obligations he may have?
You are not liable for the principal's debts as the agent on a power of attorney. But when you get the power of attorney, you just need to make sure that when you're signing things, you don't sign in your individual capacity. You sign Robert Smith, power of attorney for...
Yeah, I'm not
Smith,
liable for any financial dealings that you may owe the home or anything like that.
Right. Now, and the reason I mention this is a lot of times we see these packets from the homes.
Yeah.
And they'll have 20 pages to sign, and one of the pages, just one of them, will be a personal guarantee by you as the, quote, responsible party.
And you have to watch out for that.
You have to watch out for that.
Okay, if he dies intestate, do I need to get a lawyer to get his bank account or something like that?
Yeah, you're going to have to open up an estate.
I can't do it without a lawyer, right?
I mean, you could do it without a lawyer, but you're going to have to open the estate, go to the courthouse, do all the right stuff. So we usually recommend a lawyer, but of course I'm a little jaded.
What is that, a couple $100?
To administrate an estate, you should think about at least 1,000. I would put in that back.
He doesn't even have that much in there.
Yeah, then that's the dilemma. A lot of times there's not enough in there to make it worth opening because the court filing fee, for instance, is going to be a couple $100, right?
Well, automatically would the state later on reimburse you as your next of kin or give it?
No, it just cheats to the state, and then eventually, right, you can try to get it.
Okay.
But a lot of times when there's just a few $100s, it's just not practical. On the other hand, sometimes, I mean, he's still alive now, right?
Yeah, but he's not capable of doing anything,
Right. And if you had a power of attorney that was allowed for gifting, that would be a possibility as well.
Yeah, and I can't get one. He can't sign, so I can't get a power of attorney, right?
Right, because he's not competent at this point.
Okay, thank you very much.
All right, my friend, good luck.
Right, thank you. Bye.
I wonder if Keystone Elder Law could help us on that one at some point, Shane, which is, are there any great tricks for getting that $500 out of the bank account when that's the only estate? I wonder about that one. Rocco, you're on WHP 580 with Carl Rominger. What's going on?
Yes, how you doing?
Good.
My father-in-law just got hit in an accident.
Okay.
And the police didn't cite either one of them. Now, it's been 2 weeks, and my father-in-law has not heard from the insurance companies. They do have the vehicle, and I'm just curious what would be going on something like this.
Okay.
Because both of them have the same insurance company.
Mm-hmm.
And that's going to make it a little more difficult because I know how the deductible and all this is.
So give me the factual scenario again. Who got hit?
Okay. Say, for example, 114 in Woods Drive.
Right.
A car was coming around a bend, and he was turning to go back to his house. And the car hit him in the front, right at the front tire.
Okay.
And pushed him off. But there was no debris or no skid marks on the road. But he was, pushed off a good 12 feet from Woods Drive.
Okay.
And there was pictures and stuff taken, but neither one of them was charged with any kind of citing. Because there's no fault, I guess.
Right. Right. And nobody knows who's really at fault?
Right. And like I said, the insurance company picked up the vehicle, but they have not got back to him yet. Is that normal?
How long has it been?
It's been since the 18th.
Yeah, they should. I mean, he should be in conversation with him by now.
So,
but he may need to initiate. Anybody got hurt?
No. Well, he went to the hospital a couple times.
Right, but he wasn't really hurt in the accident?
No, not really.
Okay. Well, the answer here is
black and blue.
It sounds like
he's 87 years old and he's black and blue, and
okay.
his shoulder and his leg hurts.
Yeah, he may have a claim, but it's going to come down to who's at fault.
Okay.
So I would tell him he needs to talk with his insurance company. If he doesn't get a prompt answer, it'd be time to talk to a lawyer.
Okay.
Because usually they're pretty much on the ball with these things.
Do you handle something like this?
We would be happy to help.
Okay.
All right.
Okay, thank you very much.
All right, Rocco.
Have a good day.
You too. I'm not sure the answer on that one. Just doesn't seem like I have enough information. Alan, you're on WHP 580. What's going on?
Carl, I can kind of help you answer that question for the gentleman who has money in a bank account if someone passes away.
Yeah.
I'm a licensed funeral director in the state here, and normally what happens is somebody dies with less than $3,500 in a bank account.
Yeah.
As the funeral director, we can take a death certificate and a funeral bill to his bank or her bank, and they will write a check to the funeral home to cover the funeral expenses.
Oh.
And that is how you can close the account and help the family out to.
Very interesting.
Yes, and not a lot of people. I mean, most funeral directors know, but not a lot of people. Not a lot of people in the community do.
Yeah, and it comes up quite frequently because, as you know, when somebody dies, sometimes people promptly pay you, sometimes they don't. I know how this works, but when they do promptly pay you, and then there's like $500 left in the account, sometimes they just don't do anything with it. It would seem like if they were aware of a small amount of money in a bank account, they should talk with you right away, with the funeral director, and say, there's a small bank account. Now, here's the answer. Later, if you discover a bigger bank account or a full estate needs to be open or whatever, it doesn't matter because your bill still needs to be paid out of the estate anyhow.
That's correct. Yes, and that's what we end up doing a lot of times is, the family will come to us and say, there's a couple $100 here. How do we get it? And that's exactly what we do. We put it towards the funeral bill and,
Right.
It's all taken care of for them.
Alan, thank you very much. What's your funeral home? Give it a shout out here.
It's Dugan Funeral Home in Bendersville and Dugan Funeral Home and Crematory in Shippensburg.
Okay, well, thank you very much.
All right, thank you, Carl.
Thank you. Got to go to break. Oh, boy. I saw in the newspaper that a movie theater was robbed last night, Shane. Approximately $700 was taken. And they say thieves made off with a bag of popcorn, a large soda, and 2 tickets. Okay, no, it's not that funny. All right. I thought it was funny. All right. Well, I tell you what. I could use a margarita right about now. Margarita, what's up?
Are you the person who's going to answer my question?
I'm going to try.
Okay. I went to the magistrate because I had a landlord-tenant issue, and we won the judgment. And the lady was supposed to pay us 2 months' rent in 10 days. Mm-hmm. And when I called, because we couldn't get a hold of her daughter's the one that always answered the phone, she told us that her mother was going to pay us the rent that day. Well, 5 minutes later, the mother calls and she tells me that she doesn't have the money, that she can give us $200 a month. But by then, we were so fed up with these people, I didn't feel that I could trust her. So I said, I'm going to call the magistrate. When I call the magistrate, they tell me, we're done with your case. If you have any issues, you have to go to the sheriff's office. So I wanted to have her wages garnished, okay? Correct. So I go to the sheriff's office, and I pay again, of course, and the lady, the tenant, I don't know how she did this because I have a piece of paper that says, well, at least it says how much she was making. This is, the credit thing that the RE/MAX did. It said how much she made an hour and that she worked all this overtime. We only rented the house to 2 people, her and her boyfriend. This woman is in her 60s, okay?
Right.
So she has no tenants. No dependents. So she went, I don't know how she did this, and I don't know how a sheriff will accept something like this without any proof. She just says, you cannot garnish my wages because I have 4 dependents, and if you were to garnish my wages, that would put me below poverty levels. And that was it. So not only that, but they destroy the house. We spent more than $5,000 to fix this house,
right?
So we could rent it again. Plus, she owed us $1,600, and without all that money. So when I went to the sheriff's office, and I just could not believe that this is how the law works, And she says, "Oh, you have to go to the second floor, and you have to study the books and all this crap." Sometimes I feel like this is going to be, this happened last September.
Right.
And so, sometimes I feel like we should just look for an attorney. But my fear is, what's the attorney really going to do? I mean, she is crying poverty, and the way I feel is you can't just say, you put me below. Besides, that's her problem, not mine.
Right.
But, can somebody just go to the sheriff's office and fill out a paper and say, well, I can't pay you. You can't garnish my wages because you put me below poverty. First of all, like I said, she's 60 years old. She doesn't have any dependents. When she rented our house from us, she moved in like all her kids and grandkids, and that's how they destroy the house.
Right.
When we rented it just to two people. So I don't know where she's getting this dependence from.
Okay, well, here's the answer.
Okay.
You've got a judgment, right?
Uh-huh.
And your judgment can only be collected one of two ways. Actually, if it was a regular judgment, you couldn't garnish wages at all, okay? But landlord-tenant wages judgments, you can. So you could execute against her property, but it doesn't sound like she has anything.
Well, see, that's it. I think her furniture, it was one of these Magic's rent-to-own type of things.
Right. Or you can go for the wage, and what she's saying is the sheriff is saying that they're exempting her from garnishment because we put her below the poverty level, is what they're saying, right?
Uh-huh, exactly.
So you're without a remedy. And the answer from a lawyer is there really isn't a remedy. You have to wait till she's making more money and then try to re-garnish her again.
Yeah, so somebody told me, you should have gone, like she has 4 dependents now. When she filed for a W-2 income tax, she should be getting a big check. So, but of course that's past that time.
Right.
So, like, should I wait?
You can bring that up again and again every year or any time period you want.
Uh-huh. And if the place that she works for, are they obligated to tell me, for example, how much she makes an hour?
I don't think they're obligated to tell you. I think you have to go through the sheriff, and then the sheriff has to determine that.
Okay. But I can file every year for how many years?
That judgment will last forever as long as you keep refreshing it. I think every 5 years or so you have to just file a little piece of paper saying you want to keep it refreshed, and you can keep it trying to execute it again and again.
Uh-huh. And but if she keeps saying the same thing, there's no way to prove that she's lying. Of course.
I think you might be able to eventually ask for a hearing on that. Mm-hmm. The other thing is you could serve.
It would be worth hiring an attorney.
How much money are we talking about in the judgment?
Well, the judgment was $1,600.
Yeah, that's all you can collect.
But the damages that they did to this house, they're probably close to $5,000 or more.
But your judgment's only for $1,600.
Yeah.
Yeah, and that's your problem. Because you should have sued for the damages at the same time.
Well, see, but this is what happened. When I went to court, and they had not allowed me in the house, so I could access the damages. So I wrote like $2,000 or something. The magistrate would not accept that.
Because you hadn't seen it, right?
Well, no, not only that. I said, this is from what I see. When I saw, this is what I could tell.
But, I mean, the issue is litigated, so it's over. You didn't appeal it. You could have appealed the magistrate's decision yourself.
I didn't. I'm sorry.
You did not file an appeal of the magistrate's decision.
No. Exactly.
Yeah, so that issue's been litigated. Your judgment's only $1,600. I wouldn't spend a lot of money on an attorney chasing it down. Okay?
Okay, thank you.
Thank you. I don't have a good answer for you. That's the problem. Dave, you're on WHP 580 with Carl Rominger. Talk line number's 540-0580. What's going on, Dave?
Hey, Carl. Thanks for taking my call. I'm kind of got myself into a quandary. I guess I was subpoenaed to a court hearing. Well, I know I was.
Okay.
I didn't show up at it, and now they're saying about contempt and stuff. But the thing of it is, I didn't open that subpoena until after the hearing. I mean, it didn't come registered mail or nothing. It just came regular mail. And,
right.
I didn't open it. So what can I do?
Well, it's an easy one from my standpoint. You didn't do anything wrong.
Okay.
Right? I mean, if they hold you in contempt, they've got to prove that you knew you had the subpoena requiring your date, attendance, and time at the time you didn't show up.
Right. Okay. So what do I do?
It's a winner.
All right. Do I need to get and hire you for this?
It probably wouldn't hurt to have an attorney.
Okay, and I can get a hold of your office Monday morning, I guess?
Yes.
All righty. I appreciate it, Carl.
All right, boss. What county are we dealing with?
Lebanon.
Okay. Ah, boy. Yeah, okay, we can help.
All right, cool.
All right.
Thank you so much.
Carl Rominger here, answering your legal questions. Jay, what's going on? Hey, Jay.
Yes. Down here in York County, close to my house, is a family cemetery.
Uh-huh.
And it probably hasn't been used for 100 years.
Okay.
Somebody moved the stones from an open field into a patch of woods, I guess, to farm it.
Okay.
Number one, can they do that legally?
Well, I mean, it's a private cemetery?
Yes.
And
it's just a family cemetery.
It's their family cemetery.
And I'm sure that nobody related who's planted there owns the property. They're completely two different sets of families.
Right. Interesting. So they're trying to farm the private cemetery. I think under the Cemetery Act and whatnot, there's certain issues that apply there. I don't think you can just go ahead and start farming a cemetery.
Yep. Okay.
I think that's the short answer. I did do a little research on it, but I have a private cemetery dispute going on in another county, and there's a whole body of law that surrounds it. So it just doesn't sound right to me.
Right.
All right.
You couldn't dig up the coffins and all that stuff.
No. Exhuming remains is a whole special body law by itself too.
All right. Hey, thanks a lot.
Thank you, man. 540-0580, Carl Rominger answering your legal questions. Go to romingerlaw.com to learn more about me or join me on Facebook. And, of course, I'll be here the whole next hour answering your legal questions. Thanks.